In most deals, you're expected to be honest. But what if there was a special kind of deal where you had to tell the entire truth, even the parts no one asks about? That's what we're talking about today. It's a legal duty called utmost good faith, and it's a real game changer. So let's just jump right in with a scenario. Imagine a huge family inheritance is on the line, and a deal is struck to divide it all up. But what if that whole agreement was built on a single, massive secret? Sounds like a movie plot, right? Well, it's not a hypothetical. This actually happened, and the court case from back in 1921 completely reshaped how the law looks at honesty. And that's the case we're going to unpack. It's a story about a family's broken bargain, the case of Gordon versus Gordon. So, the scene is pretty easy to picture. You've got two brothers, right? And they're trying to figure out a really complicated inheritance from their dad. But here's the twist. There's one giant secret lurking in the background. One of the brothers knows something absolutely crucial that the other one doesn't. And that imbalance of information, that's where this whole thing kicks off. So what do you do with a situation like that? I mean, how does the law even begin to untangle it? Because this isn't about someone telling an outright lie. It's about what they didn't say. And to solve it, we have to bring in this special rule, a rule of total, complete honesty. It's a standard that's way, way higher than what we expect in most of our everyday agreements. And that principle is called utmost good faith. Now, the really key phrase here is voluntarily disclose. This isn't about just, not lying when someone asks you a direct question. No. This is a positive duty. You have to step up and share all the important, relevant information, even if the other person has no idea they should even be asking about it. Okay, to really get why this is such a big deal, you have to see how different it is from a normal contract. We're leaving the whole world of buyer beware behind and entering a completely different zone, one that demands total, upfront honesty. All right, just look at the difference here. On one side, you've got your standard contracts. The rule is caveat emptor, which is just a fancy Latin way of saying, let the buyer beware. Think of it like you're playing poker. You're trying to win, and you are absolutely not expected to show your cards to the other players. It's on them to figure it out. But then on the other side, you've got these utmost good faith contracts. This is the complete opposite. It's not a poker game. It's more like a huddle before a big play. Everyone on the team has to share what they know for the strategy to work. And that's the key takeaway here. In these special contracts, just keeping quiet about something important, well, that's basically the same as lying. Okay, so now we've got the legal concept, right? We have the tool. Let's head back to that family drama and see how applying this doctrine of utmost good faith completely solves the puzzle. So here's exactly what happened. It all started with this really complicated will that made everyone wonder if the estate was even legitimate. So the older brother, he goes off and does his own research. And guess what? He finds out, secretly, that the will is 100% valid, the inheritance is secure. Now, does he run and tell his younger brother the good news? Nope. Instead, he goes to him and says, hey, this whole thing is pretty risky. Let's just split the estate to be safe. He frames it as a smart move to avoid a potential loss. And the younger brother, thinking he's dodging a bullet, agrees to the deal. He has no idea that the risk his brother is talking about is completely made up. And you can just imagine what the court had to say about that. The judge basically put his foot down and said, look, when it comes to agreements like this, especially within a family, you can't play games. You can't hold back crucial information. As the ruling said, full and complete communication of all material circumstances is what the court must insist on. It's not a nice to have, it's a must have. So what was the final verdict? The court threw the entire agreement out, just tossed it. Why? Because the whole deal was built on a lie of omission. The older brother had a duty to be completely honest, and he wasn't. He breached that duty of utmost good faith, and because of that, the contract was toast. Okay, that's a really interesting story from the 1920s, but you might be thinking, so what? What does that have to do with my life today? Well, as it turns out, this idea is far from a dusty old legal concept. It's alive and well, and it probably affects more of your life than you think. Yeah, this principle is everywhere once you start looking for it. Think about insurance, any kind of insurance, health, life, even for your car or home. When you apply, you have a legal duty to tell them everything relevant about your health or your driving record, even if they forget to ask a specific question. And it makes sense, right? How else can they figure out the risk they're taking? It's the same deal with business partnerships or with fiduciary relationships, like between you and a financial advisor. In all these cases, one person has all the crucial info and the other is relying on them completely. That's why the law steps in and demands this higher standard of honesty. So all of this leaves us with a pretty big question to chew on. We live in the information age, right? Data is everywhere. But that also means it's easier than ever for information to be unbalanced, for one person to know a lot more than the other in a deal. So maybe it's time we asked, should more of our agreements be held to this utmost good faith standard? Should we start demanding not just that people don't lie, but that they have a duty to be proactively, totally honest? It's definitely something worth thinking about.